SJC-11879, Commonwealth v. Kenneth Dykens.
Good morning, Mr. St. Lawrence. You may proceed.
Chief Justice Gantz, Your Honors, good morning. I'm Tim St. Lawrence here on behalf of Kenneth Dykens. If it please the court, I'll first start with the issue of waiver. I submit to the court that under, as a matter of state procedural common law, a defendant does not waive his right to be free from double jeopardy by merely pleading guilty to duplicative convictions. That's what this court said in Clark 35 years ago, and that's what this court said more recently, just 3 years ago in Negron. I see no legitimate reason why this court should now change course. The current rule is sensible, it's constitutional, and it's consonant with justice.
I'm sorry, go ahead. Let's say that your client tried to break into the first floor window, was unsuccessful, left, came back a half an hour, tried to break into the second floor window, unsuccessful, left, came back in a half an hour, tried to break into the deck or something. I mean, aren't there 3 attempted break-ins there? Well,
There could be. I think the rule would be, the unit of prosecution would be the intent to commit the underlying crime, so that any acts reasonably close in time and space and purpose would all be one attempt. So it would come down to whether.
But you've redefined
that's
you've just
reasonably-
redefined the
I'm sorry.
crime. You've just redefined the criminal statute, haven't you? It's not the intent to commit the crime. It's an act, the intent to commit the act in furtherance of the crime.
Well, I think what the statute is punishing is the dangerous proximity to committing the underlying crime. So once you pass that threshold into dangerous proximity, any and all acts that you take within that threshold are one attempt.
But none of these acts depended upon either of the other acts. Each one of these, in and of themselves, resulted in a failure to break into the house. And doesn't that define the crime? It's the failure upon having committed an act just before the crime was the goal was committed.
So that each and every failure would be a new attempt. So if you're using
Yes.
a battering ram and the first hit doesn't get through the door, the second hit doesn't get through the door, the third hit, that would be 3 attempts. I don't think that's what the legislature intended. My position is that once you're in that dangerous proximity, again, and I know I'm repeating myself, but it's every act once you're in there with that intent to commit that underlying crime is the unit of prosecution and is the crime of attempt.
in dangerous proximity, you mean in terms of both time and space?
Dangerous proximity, yes, in time and space. So in your example would be a question of, okay, are those acts, those half-hour separations, are those reasonably close in time and space? And perhaps they're not, perhaps they are, but I think that would be a different question than here, where it's plain that these acts happened much closer in time than within a half hour of one
Would
another.
that, I guess I had 2 questions. Back to where you started on the Negron part.
Okay.
Wasn't there a huge passage of time between this conviction or these convictions and when this motion for new trial was filed?
There was.
Doesn't that matter?
10 years, perhaps.
Yeah.
I don't know. I don't think it matters, because I think that what underpinned Negron was that duplicative convictions goes to the Commonwealth's very right to bring that defendant into court.
Okay, so, all right. Then,
Jurisdictional issue and the adverse collateral consequences that this court recognized would still be applicable no matter when the motion was brought.
second question gets to the merits, and that is this always going to be a sort of case-by-case determination? In other words, Justice Spina's has suggested that each of these is a separate attempt, and as was actually done here, charged and found guilty. But you would say, well, in this case, it's all one attempt, but in Justice Cordy's example, maybe it isn't because it's different. So you have to look at each case on its facts, is what you're saying, in terms of what turns out to be the unit of prosecution?
Right, I do think that's right, because I think it would not be two different, it would not be one same attempt if there's a day between the first act of trying to break in the window and then he comes back a day later and tries to break in the door. That's so separated by time that that would not constitute one attempt, but in fact two attempts.
What kind of separation of time are we talking about here?
Well, that would be the question in future cases, but it would depend on the in this case, I'm sorry, in
Here.
the circumstances of this case,
Yes.
everything from the record indicates that it was all in the overnight hours of don't recall the date, but it was all within close proximity to each other, and that
So
he failed, and then
Through the
okay,
rock,
I'll
through
try.
the sliding glass door, that failed.
Right, and the Commonwealth's theory was that was the third.
That was the third.
Attempt.
What was the first one? For
So the
propping a
first
ladder?
would be either jiggling the screen on the first floor and taking that off.
And that didn't work.
That didn't work.
And so how long after that was the second one, which would
And
be
then
the
there would be
propping
the
the ladder?
That's not indicated in the record. The only way we would know that, really, I guess,
Were
would be
were they
from
asleep
Mr.
and somebody woke
Dykens.
up? I just don't remember.
After the rock got thrown through smashed the window, that was heard by the resident.
Would it have made a difference here if the defendant had walked across the street to somebody else's house to get the ladder and then brought it back? Would that have been enough of a intervening set of circumstances?
I don't think so, no, because it's still, I would suggest, so intertwined with the same purpose, intent, space. It's still close.
Intertwined as a matter of law or as a matter of fact? I mean, you're sort of would it be a jury question then as to whether it was part of the same series of acts? I mean, if it's a jury question and your client has pled guilty, that's yesterday's news.
Sure. Your point's well taken. I think it would be, though, if it's on the face of the record that it's by law so reasonably close in time. For example, the battering ram.
Of course, the battering ram, I mean, there's no guarantee that the first blow with a battering ram knocks the door down.
That's what I'm saying. So he fails on the first attempt.
Well, he didn't fail. It weakened the door, and he has to weaken it some more in order to blow the thing away.
Right, but I guess that reasoning could apply to this case as well, in that he's trying to find the best way to get in. So he's first
Well, he
moving
failed.
the screen to see if that's the best way to get in. And then he's saying, well, let me try the ladder. Maybe that's a better way to get in.
So your example would be, this is no different than, and I don't know what, but let's say you got this, the glass door that the rock went through, but there's evidence that at first he tried to jiggle it or try to do something to break the lock on the door and failed at that, and then just went and took a rock and threw it in. And so you're saying that's no different than the battering ram?
That's no different, no.
And it's no different than this case, you would say also, but it's closer to the battering ram than having three separate points of entry that are attempted.
Right.
These were three separate points of entry? The screen was on the first floor, the ladder was against the house someplace other than where the sliding glass door was that the rock was thrown through?
Yes.
And do you have any sense from start to finish how long this took?
How long it took? No.
So isn't that an integral part of your argument, though, that you have to just sort of sense that this was all within, a short period of time?
Yes.
Therefore, all one act?
That it was within a short period of time, yes.
Have that in the record.
It's not in the record because there's
How are we
really no
supposed to make
way.
that? How are we supposed to make that determination?
I would suggest that when you look at the record, it's a reasonable inference that on a cold night in February, that he wasn't out there for hours dreaming up new ways to break into the house. There's no evidence that there's footprints in the snow leaving and coming back or anything like that. So my suggestion to the court would be that it is plain on the record that these were reasonably close in time, whether it was a couple minutes between, I would still say that's reasonably close when he has the same intent throughout. He's within dangerous proximity. He's criminally liable at that point. Why should he be? He's already being punished for that. I don't see the reason why now we should start adding on separate punishments when he's already criminally liable.
Well, but you
by
could,
being-
you can see the, I mean, if you look at the deterrent factor in criminal law, you could see why separately punishing separate acts of attempt has a value, because, you know, if it's all one act, you could try 14 different ways into this house, right? I mean, so there is actually a reason why you might separately.
Sure, but okay.
What kind of a sentence did he get?
He had, on the lead charge on the attempt was 5 years committed. He had a 7-year committed concurrent on a assault that took place after the police arrived.
But on the 3 separate attempts,
He had the 5 years committed, and then on the second 2, he had concurrent probation sentences
From and after his release.
from and after his release.
Now, in Negron, I believe we said it was duplicative on its face of the indictment. But from what you're saying now, we cannot say that this is duplicative on its face. Do we need to go beyond Negron for you to prevail?
Negron, I know, I think you're right that it said, well, you wrote it, so you know, but it did say on the face of the indictment, and then it cited a lot of other cases that say on the face of the indictment and the record existing at the time of the plea. So that would take into account the plea colloquy. And I think that's how other courts look at it, but based on your footnote 5, I believe. And even Brose did that, said that. We look at the face of the indictments and the plea colloquy at the.
in this case, the indictments are all different, aren't they? Each one of them alleges
Right.
the ladder, another one alleges the rock, and the other one alleges the screen. So on their
Right.
face, they're all different.
On the face, it's different acts, but on the same date and at the same
does the-
time period.
Does the plea colloquy, is the plea colloquy part of our record?
Yes.
And as part of that plea colloquy, does it support your view that it all occurred within a very short timeframe?
Not definitively, because the only person that would be able to supply that information most likely would be Mr. Dykens, and whether he would be deemed credible in that, in a hearing or something like that. I think based on what the Commonwealth's theory was that he tried this, tried that, got frustrated, and potentially just threw the rock through the window. We know the ladder wasn't positioned when the couple went to bed that night. So we know this all happened close in time over the, I can't say definitively, no,
No, I
can't.
understand, but I'm trying to think from the point of view of the judge who's taking the plea. Person agrees to plead guilty to 3 attempts. There are 3 different acts in each of the 3 attempt indictments, so that would not necessarily trigger the judge to say this is the same attempt. The plea colloquy doesn't make clear that it all occurred as one of a single continuous point in time. So what's the judge supposed to do? Supposed to sort of say, I need to learn more about the timing to evaluate whether or not it's duplicative?
Does he need to then hold a hearing, essentially, an evidentiary hearing to?
Well, I mean, a judge has an obligation not to take duplicative pleas, but I'm trying to figure out what a judge pragmatically is supposed to do in this case, what we would have expected a judge to have done here.
Well, obviously, I think the case law says he can look at the face of the indictments and the record existing at the time of plea, and in his determination, based on those facts, whether these acts were reasonably close in time and purpose and space, that they constitute one single attempt rather than multiple counts of attempt. I see I have 30 seconds left. I just wanted to say that the The burglar's tool statute doesn't say anything that is capable of breaking or is actually used to break. It cabins it into an engine, machine, tool, or implement, and I would suggest that a rock is none of those things.
Does the
its
indictment
character.
say rock?
The indictment says rock,
Heavy rock.
heavy rock.
Well, tools were originally made out of rocks, were they not?
Right, maybe 1.5 million years ago, a tool was, a rock was a tool. But even then, they were shaping them and to their needs. So I would suggest that doesn't fall within the ambit of the statute.
Okay, thank you.
Thank you.
Good morning. May it please the court. Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth.
I have to admit, counsel, I was amused about the rock. Does this happen often, that's charged as a burglarious implement?
I don't know, Your Honor. I have not gathered statistics on this.
I handled
But-
a lot of those in my youth, and I mean, lots of other things,
But you never
a
used
rock.
one to break into a house. I assume. I'm not asking.
I was going to say, on the advice of
and it's
counsel,
none
he's
of
going to
my
remain
business.
silent.
A rock can be a tool if it is used to break into a house. A rock can also be a tool if it is altered in some way to make it more effective for breaking into a house. We don't know whether that was done in this case for the same reason that we don't know
What
whether the
possi-
defendant went away for a half hour in between his attempts.
Well, let's get back to the rock for a second. What do you mean you don't know? You saw the rock, right?
It could have been part of a bigger rock.
Did you say, what kind of rock are we talking about here?
I haven't seen it. It's a
Was it,
rock.
was it in the house?
Somebody
Was
saw it.
It was in the yard.
No, was it thrown in through the glass door into the house?
I think it was on the patio. I think it was
Did
sort
it
of
break the glass?
It broke the glass, and my memory of the colloquy is that the facts as recited in the colloquy was that he seemed to have had it in his hand and then dropped it.
So is it
It
the-
wasn't through into the living room, as far as I recall.
So is the very act of throwing it, the using it to break glass, is that what you're saying is tool-like, that it's?
Potentially,
it's-
yes.
What do you mean potentially?
I think that is an adaptation of the rock,
To use it,
to use it
as
for
opposed to just
that
let it
purpose.
sit on the ground?
What
Yeah.
the defendant is arguing, and because we don't know because he pled guilty. This was something that could have been a question of fact put before the jury. It was something that could have been the subject of a motion for a required finding. None of those things happened because the defendant pled guilty, and by pleading guilty, he agreed that it qualified as a burglarious instrument. This court would have to find that there is no circumstance and no universe in which a rock could qualify as a burglarious implement. in
No
order to
universe? We're
reverse
not
it.
really going that far, are we really?
No circumstance in this universe.
Could I
has
go
that.
back to the temporal connection?
Yes.
So I thought there was one, at least this is what I envisioned when I read the colloquy, which is that they noticed fresh and distinct footprints and followed them to where they found him hiding, suggesting a single period of time, not a lot of crisscrossing, no difficulty finding, distinct, fresh and distinct, and followed the track, so one track out. That's what this says to me.
That's what was
Does
recited.
it make a difference?
No.
Doesn't make a difference
No.
to you. Should it
It-
make a difference, though, to us, I
No.
guess?
No, I don't think it should. I think, again, we don't know whether there were other footprints. We don't know whether the defendant actually did go away and get himself a cup of coffee and think it over and say, maybe I'll try the second story window. We don't know any of that because the defendant pled guilty.
Well, we know what's in the colloquy.
The colloquy does not establish the time frame. It does not establish how long from the first attempt to the last.
Do you think we should be worried about that at all in
No.
any case?
No,
Take
I-
the battering ram case. Your argument would be that's a whole different case.
I think the battering ram is a different case because I think with a battering ram, as Justice Spina pointed out, this is a series of not preparatory, but successive acts in a single attempt under the continuing offense doctrine as articulated in Horn.
So, but it would be different if a battering ram tried on the kitchen door, didn't work, battering
Go
ram
around
tried
the
on the
back and
cellar
try it on
door,
the deck door.
that would be
Yeah.
two.
That's two attempts.
And what about if a battering ram is used, and then it makes you tired, so you sit down and you rest for a little while, and then you come back and you pick up the battering ram. Is it, and you know, I don't know where we're going with this from a conceptual point of view.
I think that's a closer case, but I will say this, the gravamen of attempt is the failure. And that's why this case is different from Resendiz-Ponce, which the defendant cites. In Resendiz-Ponce, you have a series of acts, all of which are necessary for the single unsuccessful attempt. Here we have 3 separate, distinct acts, and each one, had the act been successful, had he successfully gotten through the second-story window using the ladder, had he successfully gotten through the first-floor window that he pried the screen off of, and had he successfully gotten through the deck door,
Let's say, just take the window.
any of those would have been a
Well,
completed
but
B&E.
yeah, but that's because they're different locations, so it makes it a little easier for you. Let's say it's the same door, and he jiggles it, and they hear him jiggling. Oh, and he says, oh, it's locked. So let me just smash it so I can get on the inside and get it. 2, 1. You don't know.
It's
How
a
about
more
the
difficult
same other
question.
window? How about he gets on a box, whoops, I'm not tall enough, let me pull this ladder that's right over here. Oh, I'm tall enough, now I get in there. 2 or 1?
I think that's more likely to be 1.
Why?
I think
He tries to-
because it is there's a single goal, the single
There's a single goal here,
attempt
too.
at the goal. No, it's for 3 different methods.
goal
and
is
each
to get
one-
into the
and
house.
each one
Right.
fails before he goes back and tries another different.
I think perpetration might be important, which is the use of the word in the statute. The goal of perpetration, that is here to gain access for the purpose of committing a robbery,
Okay, now, if you want to talk about
maybe.
absurd and unjust results, that interpretation rewards the perpetrator who keeps trying until he gets in.
Well, we'd like to reward effort.
Normally, yes. Normally, persistence is a virtue. I don't think the legislature meant to reward this kind of persistence.
But
And
is it fair to say that we can reject the trial judge's view that the term act, singular, is what determines this case?
I think by itself, that determination does not resolve all questions raised by this case, because that interpretation does not resolve a question in a case like Resendiz-Ponce, or the case in which he puts the ladder up against the wall, climbs the ladder, and then gets in the window. That's not 3 attempts. That's
committing.
3 acts in a single attempt.
So the issue is not whether there was an act in furtherance of the attempt. The act is whether there was an attempt.
There was an attempt that failed.
Failed
And here
in
you
the
had 3,
perpetration.
and they all failed in separate and distinct ways.
So in terms of establishing a principle, it sounds to me that that the location of the fact that there were 3 different locations seems critical to
I think
your
it's
argument.
important. I think it's important. I wouldn't say it would be dispositive in all cases. But I think in this case, it is probably the most telling fact.
So you're saying
And it is the one thing-
proximity in time and the same location would make it likely to be a continuing?
Not necessarily. Not necessarily, but I think that tends to tilt the balance in the direction of one attempt. I wouldn't say it would the same location necessarily makes it a single attempt. There could be an issue of the method, also of temporal separation. But I also want to point out that my brother has been using this reasonably close.
The problem is that if this case goes to trial, this is going to be a jury question.
Exactly.
And
It is a
so I
jury
haven't-
question?
I
So-
think it
So
is
if
a
the
jury
Commonwealth
question.
charges 10 things, then it's going to be up to the jury whether it's 10 or 1?
I think it depends on it's a jury question, potentially a required finding question. It is a fact-dependent question. So in that sense, it is a jury question. It is something that the defendant resolved. He raised it before trial, lost, took the loss by pleading guilty, served his sentence, got partway through his probation, violated his probation, had his probation terminated. It's purely academic by the time he raised it.
Well,
He was already a habitual offender when he pled. that the defendant knew this was an issue, it was resolved against him, and he accepted that resolution by pleading. Now, I
But on
understand
your
that...
theory, then, there's no, pleading does eliminate any ability to argue double jeopardy, as you view it.
I understand the cases that say double jeopardy can be raised at any time, and it may be that I'm just sort of raging in the dark on this. I do think this case is different from Negron. The indictments in Negron were duplicative on their face. They are not here. They are duplicative only as a matter of facts of the case, which the defendant admitted and agreed that these facts constitute a violation and constitute separate violations. And I think there is that the Commonwealth and the victims have a right to repose and finality, and that right is profoundly disturbed by allowing this. I think ultimately that doesn't matter because there is no double jeopardy violation here. These are distinct offenses. Each one was preceded by the failure of the previous one, and there is no reason to consider the waiver issue because the indictments were not duplicative.
If this were a trial, what does the judge say to the jury in instructing them on how to consider these three acts?
I think he would have to, as we instruct all the time, judges instruct, you need to consider each indictment separately. And you need to consider whether, and I think he could instruct, you need to consider whether each act constitutes a separate attempt. I don't think there's a problem.
That's all? No.
We don't know because he didn't go to trial.
I know, but I'm just trying to figure out, you say it's a fact question, and I'm just trying to figure out how do we evaluate what happened here? What is the standard for determining whether it's a separate act or whether it's the same act? I mean, if it's a jury trial, the jury has to be told something.
I think we have to.
And I'm trying to figure out what is the principle? What are they told?
They are told, here is what constitutes an attempt. Intent to commit the underlying crime, an act that comes reasonably close to completion, and non-accomplishment of the underlying offense. That's how we always instruct in attempt cases. You have heard evidence that these three acts were committed. If you find that they were committed, you must find the defendant guilty.
Well, that decides
that
it as
will
a
be-
matter of
That's
law.
not, that's not a fact question, is it? Maybe, I think let's put it this way, it's a sort of a mixed question because it does depend on the facts of the case. We've been going back and forth with different scenarios, and would this be a single offense? Would this be multiple offenses? It does depend on the facts of the case, but whether they're duplicative or not would not be a jury question.
So the difficulty in figuring out what the instruction should be makes me wonder if it's a question, is this a question of fact or is it a question of law? Whether it's one act or three acts. Is that something that the judge should always decide before the case goes to the jury?
Well, I think where it's raised before the case goes to trial, yes, the judge has to decide it. That is exactly what happened here. And the defendant accepted that resolution.
So it's not a question of fact then?
But it has to be decided on the facts of the offense.
If the judge in this case had refused to instruct whether or not the jury, requiring the jury to decide whether or not it was one act or three separate acts, if the judge had refused to do that and said, I'm going to give them these three separate indictments because I don't think that the facts, as a matter of law, warrant the kind of instruction the defendant is looking for, whatever that might be, would the judge have been wrong?
I'm sorry, say that one more time.
Would the judge have been wrong to say, I am not going to instruct that the jury might consider some theory under which all three of these attempts conceivably could have been a single attempt? would he have been wrong to refuse to do that?
I think, and I realize I'm backtracking a bit here. I think that the question of whether these constituted a single attempt should probably not be submitted to a jury.
In this
Because
case?
we do, in this case, well, I think in any case, I think that a double jeopardy question is not something that a jury decides. That's a question of law, but it's a question of law that's resolved on the record, on the facts, on what's alleged in the indictment. I mean, it's not something that's considered in a vacuum. And if we had tried to indict 3 blows of the same battering ram, we probably would rightly be dismissed under the continuous offense doctrine. But that's because the facts are different.
Okay, thank you.
Thank you.